It was the summer of 1982, a lonely stretch of highway in Montana, and a hitchhiker named Ronald Allen Smith stood under the fading sun, his thumb raised, his mind clouded by drugs and alcohol. Two young black men, Harvey Madman 23 and Thomas Running Rabbit 20, stopped to help. They didn't know they were picking up a killer. Hours later, deep in the woods near East Glacier Park, the car stopped. Smith pulled out a gun. The men were ordered out of their vehicle, forced to walk into the trees. Then, without warning, Smith raised the weapon and fired execution style. Two lives ended before the echo of the gunshots faded. When police found the bodies, the scene told a story of cruelty and chaos, stolen belongings, footprints in the mud, and a discarded revolver. Days later, Smith was caught in Wyoming, still wearing the victims' clothes, driving their car and laughing. He confessed almost immediately. "I did it," he told officers. "I wanted to know what it felt like to kill someone." But as the shock spread across Montana, something even more disturbing began to unfold. In court, Smith didn't ask for mercy, he demanded death. He told the judge he deserved to die, that he wanted to be executed. And yet, as the years went on, that certainty faded. From his prison cell, the man who once begged to be killed began to plead for his life. He found religion, claimed remorse, and asked for clemency, sparking a decades-long battle between Canada and the state of Montana over the fate of one man who had lost everything, including his soul. This is the story of Ronald Allen Smith, the only Canadian still on death row in the United States, a man who wanted to die until he didn't. Classification, murderer characteristics. Hitchhiking, drug and alcohol-fueled rampage. Number of victims, 2. Date of murders, August 4th, 1982. Date of arrest, August 27th, 1982. Date of birth, September 7th. 19. Victims profile, Harvey Madman. 23 and Thomas Running Rabbit. 20. Method of murder, shooting with a sawed-off .22 caliber rifle. Location, Glacier County, Montana, USA. Status, sentenced to death on March 21st, 1983. Ronald Allen Smith, born September 7, 1907, is a Canadian man who was sentenced to death in Montana for murdering 2 people. As of 2011, Smith is one of 2 prisoners on Montana's death row. The other is William Golahan. Judge Jeffrey Sherlock granted Smith a stay of execution, so his civil lawsuit challenging the constitutionality of lethal injection could be decided. Murder in Montana. Smith, who is from Wetaskiwin, Alberta, was sentenced to death in March 1983. 7 months earlier, he killed 2 Aboriginal men who offered him a ride while hitchhiking. He marched cousins Harvey Madman 23 and Thomas Running Rabbit 20 into the woods by the highway and shot them both in the head with a sawed-off .22 caliber rifle. Smith refused a plea deal that would have seen him avoid death row but spend his life in prison. He pleaded guilty 3 weeks later and then asked for and was given a death sentence. Later, he changed his mind. Smith has had several previous execution dates, but each has been overturned. November 2001, the United States Supreme Court denied a petition for review. In 2000, the U.S. Supreme Court refused to hear his final appeal, and the case was sent back to the state of Montana for another date for execution. Canadian government involvement. The government of Canada had maintained an interest in Smith's case since 1983, with Canadian consular officials communicating with some regularity with Smith, with his lawyers, with prison officials, with the Office of the Governor of Montana, with other Montana state officials, and with the U.S. Department of State. Beginning in 1997, Canadian consular officials had requested clemency for Smith on humanitarian grounds. The governor of Montana apparently showed some sympathy to these requests. In October or November 2007, however, the government of Canada announced that it would not seek clemency for Smith. Whereas Canadian government policy had always been to seek clemency through diplomatic channels for Canadians sentenced to death in foreign countries. The government now announced a new policy that multiple murderers and mass murderers who are convicted in a democracy that adheres to the rule of law cannot necessarily count on a plea for clemency from the Canadian government and patriation back to this country. As of 2010, Smith remains on Montana's death row. Counsel for Smith launched a proceeding in Canada's federal court against the cabinet ministers responsible for the change in Canada's policy. In a decision rendered on March 4, 2009, Mr. Justice Barnes found that the Canadian government did not have a coherent new policy on seeking clemency in death penalty cases, and therefore the government was required to apply the former policy to Smith's case. The court did not determine whether there is generally a legal duty on the government to help its citizens sentenced to death abroad. Rather, the court based its decision on issues of procedural fairness, holding that, before withdrawing support of Smith's clemency application, the government had a duty to consult fully with Smith and his legal advisors, followed by a fair and objective consideration of the appropriateness of applying any new policy to the facts of his case. In the result, the court ordered the government of Canada to take all reasonable steps to support Smith's case for clemency before the governor of Montana and his advisors in accordance with the current government policy. The government did not appeal the ruling of the federal court, and on June 19, 2009, Minister of Foreign Affairs Lawrence Cannon said that the government is complying with the court ruling. Earlier the same day, Cannon explained the government's policy as follows. Our government respects the decisions made by sovereign democratic states. We are determined to ensure that justice is served for Canadians abroad. In that regard, we will continue to study each instance on a case-by-case basis, and, where appropriate, seek clemency for Canadians facing the death penalty abroad. Smith is, as of 2011, the only Canadian on death row in the United States. Albertan on death row in Montana expects state will end executions. Carolyn Dunn interviews Ronald Allen Smith, the only Canadian on death row in the U.S. March 16, 2009, a Canadian man on death row in Montana State Prison says he believes he may get clemency now that lawmakers in the state legislature are voting next month on whether to end the death penalty. I'm figuring here in the next month I won't have a death sentence anymore, Ronald Allen Smith told CBC News during an interview in the prison near Deer Lodge, Man. The 51-year-old man from Red Deer, Alta, is the only Canadian on death row in the U.S. He was convicted of killing 2 young Aboriginal men while hitchhiking in Montana in 1982. Capital punishment exists in 36 U.S. states, but several, including Montana, are now debating whether to end the practice. In February, the Montana Senate approved a bill that would abolish capital punishment. It's now being debated by state legislature representatives who are expected to vote on the bill mid-April. Smith says he's remorseful. In the interview, Smith told the CBC's Carolyn Dunn that he is a changed man and deserves to live. I realize just through interactions with my own family, I realize what I've done to the families of the 2 victims, he said. So there's no doubt there's a lot of remorse. I'd give anything to be able to go back and change that day. I can't. On August 4, 1982, Smith shot and killed 20-year-old Thomas Running Rabbit Jr. and 23-year-old Harvey Madman Jr. near Glacier National Park in Montana. He marched the 2 cousins into the woods by the highway and shot them both in the head with a sawed-off .22 caliber rifle. Smith initially pleaded not guilty, but withdrew his not guilty pleas and pleaded guilty and asked to be executed. The court granted him a death sentence, but he later changed his mind and appealed the decision. For years, the Canadian government lobbied for his clemency, but under Stephen Harper's Conservatives, the government changed its mind. We will not actively pursue bringing back to Canada murderers who have been tried in a democratic country that supports the rule of law. Then Public Safety Minister Stockwell Day told the House of Commons in November 2000. On March 4th, a federal court ruled that the government couldn't suddenly change a policy without adequate explanation and ordered it to resume efforts to win Smith's clemency. The Canadian government is reviewing the ruling to decide whether to appeal the decision. But that may be moot if Montana votes in favor of abolishing the death penalty. If that happens, Smith's sentence would be reduced to life imprisonment. Execution would bring peace to one victim's family. Smith himself seemed conflicted about the possibility of being granted a reprieve. It's 6 of one, half a dozen of another, because in all probability it means I'll spend the rest of my life sitting in prison, said Smith, who hopes to be transferred to a Canadian prison to be closer to his family. I'm not real pleased with that thought, so it's a little bit of a relief. But at the same time, I'm stuck here. For the family of one victim, Smith's execution is the only thing that will bring peace. I wouldn't have to think about it every day, said Thomas Running Rabbit Sr. Every day I get up, I sit and drink a cup of coffee, and I look at my son's picture and think about it. It's just like it happened yesterday. There's no change. Gary G. Doran argued Kalispell for defendant and appellant. Mike Greeley, Attorney General James Shire argued Astonwood Attorney General Helena Ted Olympus County Attorney Kalispell for plaintiff and respondent. Harrison Justice. The defendant, Ronald Allen Smith, was convicted of aggravated kidnapping, 2 counts, and deliberate homicide, 2 counts. The defendant was convicted of each count pursuant to pleas of guilty entered in the District Court of Flathead County, State of Montana. The defendant was sentenced to death. The judgment and sentence were affirmed by this court in State v. Smith Montesouls, 1985. 5705 P2 1087 42 St. Rep. 463. This court is again asked to reconsider the record and remand the matter for an additional psychiatric evaluation of defendant and a rehearing of the defendant's sentence based upon a United States Supreme Court case of Ake v. Oklahoma, 1985 at U.S. Monk 105 SGE 1087-84 LD 53, which came down after argument in this case. On August 4, 1982, defendant kidnapped and killed Harvey Madman Jr. and Thomas Running Rabbit Jr. at a remote location near U.S. Highway 2, west of the eastern border of Flathead County. On August 3, 1982, the defendant and 2 companions, Andre Fontaine, and Rodney Monroe had departed from Alberta, Canada. The three encountered the two victims, Madman and Running Rabbit, at a bar in East Glacier, Montana. While at the bar, the three shot pool and drank beer with Madman and Running Rabbit. The three left the bar in East Glacier and hitchhiked west along Highway 2. There had been discussion between the defendant and Andre Fontaine about stealing a car and the need to eliminate any witnesses to the theft. Shortly thereafter, the three men were picked up by Madman and Running Rabbit. The men drove for approximately 20 minutes and stopped to allow Madman and Running Rabbit to relieve themselves. When the two men got back into the car, the defendant pulled a sawed-off single-shot bolt-action .22 rifle brought illegally into this country and pointed it at the driver. Monroe displayed his knife to the passenger. The defendant and Monroe marched the two victims into the trees. The defendant shot Harvey Madman in the back of the head at point-blank range. He reloaded the rifle, walked several feet to where Thomas Running Rabbit had fallen to the ground upon being stabbed by Monroe, and shot him in the temple at point-blank range. Both men were killed instantly. The defendant and the other two then stole the victim's car and proceeded to California. The car was later recovered when Fontaine and Monroe were arrested for armed robbery in California. The defendant was arrested in Wyoming. An information was filed charging the defendant with 2 counts of aggravated kidnapping and 2 counts of deliberate homicide. An arraignment hearing was held on November 1, 1982, at which time the defendant entered a plea of not guilty to all charges. On February 24, 1983, the defendant entered a change of plea. The defendant admitted shooting both victims in the head. The court was apprised of the defendant's intention to seek the death penalty. At the sentencing hearing on March 21, 1983, the court and parties reviewed the pre-sentence report, and after one minor correction, the court admitted it without objection. At the hearing, the defendant testified that he had been in prison for 8 of the last 10 years, and that he had lived by petty theft and selling drugs when he was not in prison. He testified in detail about the 16 prior offenses listed in the pre-sentence report. He testified to the facts of the killing. He stated that Monroe was aware of his intent to kill the victims because he intended to steal their car and wished to leave no witnesses. He stated that in addition to his desire to eliminate the witnesses to the car theft, he had had a morbid fascination to find out what it would be like to kill somebody. He testified that he had consumed 2 or 3 beers on the night of the crime, but that his ability to understand his actions were not impaired. He testified he sought the death penalty because a prolonged period of incarceration would be of no benefit to himself or society, and because he foresaw problems with the Indian population at the prison. He testified that he felt no remorse for the killings, that he considered himself a violent person, and that he felt he could kill again. He stated that he had no desire to change his lifestyle. Following extensive questioning by the court, the defendant denied being under the influence of drugs, intoxicants, or extreme stress, and stated that he knew of no mitigating circumstances. On March 21, 1983, at the conclusion of the hearing, to determine the existence and nature of any aggravating or mitigating circumstances, the court imposed a sentence of death upon the defendant. Subsequently, the defendant filed a motion to seek a reconsideration of the death penalty and a motion for a psychiatric examination. The court held a hearing on the motions on May 3, 1983. At the hearing, the defendant testified that his family had induced him to change his mind and seek a lesser penalty than death. He testified that his earlier desire for the death penalty was the product of depression, which had resulted from the long period of solitary confinement in the Flathead County Jail following his arrest. He further testified that he had designed his earlier testimony to induce the court to sentence him to death, and that he had concealed a potential mitigating factor, his use of drugs and alcohol. He testified that he and Monroe had used 300 or 400 hits of LSD during the period of time immediately prior to their entry to the United States, ending the day before the murders. He further testified that on the day of the crime, he had consumed approximately 12 beers. On June 10, 1983, the court granted the defendant's motion for psychiatric evaluation. The court appointed a psychiatrist, Dr. William Stratford, to examine the defendant and report to the court as to 1, whether he could determine which of the versions given by the defendant was credible, and 2, what was the defendant's mental condition on August 4, 1982. The defendant requested the court to amend its order, deleting the investigative function of Dr. Stratford. The court amended its order and directed Dr. Stratford to assume the truth of defendant's second version of the facts in performing his examination. The court held a hearing on defendant's motion for reconsideration of the sentence on December 1, 1980. At the hearing, Dr. Stratford testified that he found no evidence that the use of drugs or alcohol affected the defendant's capacity to appreciate the criminality of his conduct, conform his conduct to the requirements of law, or form a criminal intent. He based his conclusions on the defendant's testimony and statements regarding his extensive use of LSD and his conduct on the day of the crime. According to Dr. Stratford, after 3 or 4 consecutive days of heavy LSD usage, the user develops a tolerance for the drug. As a result, large doses have little or no effect. Given the defendant's history of heavy LSD usage for a period of 1 month or more prior to the crime, Dr. Stratford concluded that the use of 8 or 9 or even as many as 50 doses of LSD would not have affected the defendant's mental state when he committed the homicides. Rodney Monroe, the defendant's accomplice, also testified at the hearing. Monroe stated that at the time of the crime he was experiencing confusion, flashes of light, and hallucinations, having ingested approximately the same amount of drugs and alcohol as the defendant. He also testified that he had stabbed Running Rabbit once before the defendant shot him, and that it was possible Running Rabbit was already dead before he was shot. On December 12, 1983, the defendant filed his motion for an additional psychiatric evaluation. The defendant's motion was denied. In reviewing defendant's motion for reconsideration, the court entered findings of fact and conclusions of law to support its original sentence. The court found that beyond a reasonable doubt, the aggravated kidnappings committed by the defendant resulted in the death of his victims, satisfying the statutory aggravating circumstance stated in Section 46-18-303 MCA. The court found beyond a reasonable doubt that no mitigating circumstances were present. The court found that, without exception, the defendant's consumption of alcohol and drugs was voluntary and did not impair or otherwise affect his state of mind, his capacity to recognize and appreciate the criminality of his conduct, or his ability to control his actions and to conform his conduct to the requirements of law. The court concluded that the defendant made a conscious and voluntary choice to kill the victims, notwithstanding his use of drugs and alcohol, and that intoxication was not a sufficient mitigating circumstance to call for leniency. The defendant appealed from the sentence imposed. We affirmed. State vs. Ronald Allen Smith Supra. Defendant's petition for rehearing is based on Ake v. Oklahoma, 1985 and U.S. Auto 105 SKT 1087, 84 Ella T 53. Our province on the appeal is to determine whether the defendant is entitled to an additional psychiatric exam under Ake Supra. The defendant argues that the Ake decision established a constitutional right for defendants' access to competent psychiatric assistance, where such assistance is essential to the effective defense of the case. The defendant argues that, in light of the Ake decision, he is entitled to an additional psychiatric examination. We disagree. We find the Ake decision lacks direct application to Montana's capital sentencing proceeding and to the present case. In Ake v. Oklahoma Supra, an indigent defendant was charged with first-degree murder. At his arraignment, the trial judge ordered him to be examined by a psychiatrist due to his bizarre behavior. The defendant was initially found incompetent to stand trial, but 6 weeks later, he was found competent, so long as he continued to be sedated with antipsychotic drugs. The defendant raised the insanity defense and requested a psychiatric evaluation to determine his mental state at the time of the offense. The trial court denied defendant's motion for such an evaluation. The United States Supreme Court reversed and held that when a defendant has made a preliminary showing that his sanity at the time of the offense is likely to be a significant factor at trial, the Constitution requires that the state provide access to a psychiatrist's assistance on this issue if the defendant cannot otherwise afford one. We find the Ake decision readily distinguishable from the case at bar. First, the psychiatric testimony in Ake raised the issue of the defendant's future dangerousness, which in Oklahoma is a statutory aggravating factor in a capital sentencing proceeding. Oklahoma Statute Title 21, 152, 1981. In Montana, future dangerousness is not a statutory aggravating circumstance under the state's capital sentencing scheme, Section 46-18-303 MCA. Unlike the situation that existed in Ake, the state did not rely upon or present psychiatric evidence to establish any aggravating factors at sentencing. Further, in this case, at no time did the state attempt to elicit from Dr. Stratford an opinion concerning future dangerousness of the defendant. Second, in Ake, there was a trial. The defendant's sanity was a significant factor in his defense. In the present matter, the defendant pled guilty to the homicide and aggravated kidnapping offenses. Third, in the United States Supreme Court decision, there was no expert testimony for either side on Ake's sanity at the time of the offense. AC 105 SKT at 1091. However, in Smith Supra, Dr. Stratford, the psychiatrist, gave extensive testimony as to the defendant's state of mind at the time of the offense, including the effect of alcohol and drugs on the defendant's state of mind. B, whether the defendant acted under extreme mental or emotional stress. C, whether the defendant's capacity to appreciate the criminality of his conduct to the requirements of law was substantially impaired. And D, a diagnosis of the defendant's mental condition. State v. Smith, 42 St. Rep. at 479-705 P2D 1087. Fourth, in Ake, the trial court denied defense counsel's request for a psychiatric examination of defendant with respect to his mental condition at the time of the offense. In the present case, the trial court granted defendant's initial request for the psychiatric evaluation. Following the examination and the psychiatrist's conclusion regarding the defendant's state of mind, the defendant filed a motion for an additional psychiatric evaluation. The second motion was denied. Based on the foregoing, we find the Ake decision readily distinguishable and without precedential merit to this case. The defendant also argues that he was not provided with a competent psychiatrist. The defendant repeats his contention raised in the initial appeal that Dr. Stratford's role was contaminated by the investigative function imposed by the district court. This contention raised by the defendant in his briefs and argument is identical to that in the first appeal state v. Ronald Allen Smith supra. We have considered the argument not only in light of the issues raised in the original appeal, but also on the Ake decision. The United States Supreme Court in Ake noted, "This is not to say, of course, that the indigent defendant has a constitutional right to choose a psychiatrist of his personal liking or to receive funds to hire his own. Our concern is that the indigent defendant have access to a competent psychiatrist for the purpose we have discussed, and as in the case of the provision of counsel, we leave to the state the decision on how to implement this right." Emphasis added. Ake Supra 105 SKT at 1097 T at. The basic tenet of the Ake decision was to assure an indigent defendant's access to a competent psychiatrist for the preparation of a defense based on his mental condition. We find the defendant was afforded this right. The record clearly reflects Dr. Stratford's educational and professional qualifications. Dr. Stratford interviewed the defendant on 2 occasions at the Montana State Prison and considered the transcripts of the prior proceedings, the presentence report, and witness statements provided by the defendant. Dr. Stratford also interviewed Rodney Monroe and Andre Fontaine and secured a psychological profile of the defendant from Dr. Herman Walters. Dr. Stratford's conclusion was that Smith had the capacity to appreciate the criminality of his conduct and that the drugs and alcohol did not have a substantial effect on the defendant's state of mind. The record demonstrates that Dr. Stratford was a neutral psychiatrist who examined Smith as to his sanity at the time of the offenses. Dr. Stratford testified to the foregoing at the hearing, and it was on that basis that this court found no additional psychiatric evaluation was necessary. Accordingly, we find that Ronald Allen Smith is not entitled to a second psychiatrist's evaluation. We concur. Turnage. C.J. and Weber Morrison, Sheehy Hunt, and Goldbranson, J.J. concur. And so the story of Ronald Allen Smith, the only Canadian still facing death in the United States, remains suspended between 2 worlds, guilt and redemption, life and death. For over 4 decades, Smith has lived in a concrete cell at Montana State Prison, his fate decided, yet never carried out. The man who once demanded execution now wakes each day waiting for a call, a word that could either end his life or extend it 1 more year. He has watched others around him die. He has watched the seasons change through a small window. He has written letters filled with regret prayers and questions no one can answer. He says he's no longer the man who pulled the trigger in 1982. But for the families of Harvey Madman and Thomas Running Rabbit, the years haven't healed anything. Their sons never came home. Their pain never faded. To them, justice means closure, not compassion. To Smith, mercy means humanity, not forgiveness. And so the debate continues. Should a man who confessed to killing 2 innocent strangers be allowed to live? Or has he suffered enough trapped for decades in a living death sentence? In 2025, Ronald Smith is still waiting, caught in the endless space between a court's decision and a governor's pen. Perhaps the most haunting part isn't whether he lives or dies. It's that the world stopped paying attention long ago. This is not just the story of a killer, it's the story of time punishment and what happens when a man asks for death and then learns to fear it.